Excited to be with you here today, and particularly excited that Commissioner Holyoak agreed to spend some time with us today, particularly in the midst of everything that is happening on the federal stage. So thank you for being here with us. Calvin did introduce Commissioner Holyoak, but I do just want to note a couple of things. It's really amazing that we have Commissioner Holyoak here in Utah and that she is one of our own. I first met Commissioner Holyoak when she came back to Utah from Missouri with her family to serve as Solicitor General for the Attorney General's office. And in that role, she oversaw the civil appeals, criminal appeals, constitutional defense, special litigation, antitrust cases, data privacy cases, really the whole gamut of everything, including multi-state litigation and things that touch this industry as well. Before taking on that role, she was the president and general counsel of Hamilton Lincoln Law, a Washington, D.C.-based public interest law firm that also focused on competitive enterprise institutes, all of the unfair cases, all of the things along those lines. So Commissioner Holyoak also attended
we're also friends.
Law school at the University of Utah. So we are really excited that we have one of our own here from Utah. And again, thank you for taking the time to be here with us today. And we are friends, so it's great. But I do want to ask you, just to start out, how did your experience as Solicitor General here in Utah impact your work, your current work, and how did that shape that?
Absolutely. And I'm so happy to be here. Thank you for the invitation. I am very lucky because I live in Utah and I just commute back and forth. Even though we're in shutdown, I am able to attend this because all of my other travel has been canceled. So I'm thrilled to be here today. And I also will start with my typical disclaimer. My thoughts today are my own. They do not necessarily represent those of the Federal Trade Commissioner or any other commissioner. So my experience in Utah as Solicitor General did really shape how I approach my position as a commissioner in a couple of different ways. I think first and foremost, it gave me the perspective of the states. So when I have a case come to me, for example, either a consumer protection case or a merger case, for example, a merger comes to me and I know that there's a particular impact to a state, one of the first questions I'll ask staff is, what are their views on this? What does the AG think in that particular state? What are their views on this? And in all of those matters, I want to understand the state's perspectives because I was on the other side, and we will coordinate together, but having that perspective can be really invaluable. I think another thing that really has shaped how I've approached the FTC is my work in the SG. I spend a significant amount of time pushing back against federal overreach. And the bases for a lot of those actions was that the federal government just did not have the authority to do what it was trying to do. So I take that very in mind as I'm approaching everything we do. I'm very keenly aware of where is our authority coming from to take whatever particular action we're trying to do. And I think the last thing that has helped has impacted my approach is some of the issues that I worked on as SG continue to be some of my priorities at the Commission. For example, working on cases that have impacted kids, protecting kids online. So that has been a priority and remains a priority for me.
Okay, thank you. I'm going to shift, or I guess start with an issue that's been a really big topic in Utah for the last several years, which is non-compete agreements. The FTC has recently taken this up. For companies like those in the life science with really long-lived IP, this is a really significant issue. For others, maybe not as impactful. But how has the FTC viewed this issue, and what are you working on currently in the policy area?
A great question. So this was one of the first things that I had to decide when I first came to the Commission. The previous administration had put forward a non-compete rule, which would basically ban all non-competes. And I looked at the rule, and I dissented. I did not support the rule, and for a couple of reasons, but the most important being that we did not have the authority to do competition rulemaking. And just to give you a little bit of perspective, in the 110 years that the FTC has existed, the FTC has only tried to create a competition rulemaking one time. They did never actually enforce that rule, and they afterwards had repealed it. So this is very unprecedented. The previous administration, what they tried to do is say that we had authority to do this based on two different sections of the FTC Act. Section 5, which sets forth our adjudication process, our case-by-case adjudication of matters, and Section 6, which sets forth some miscellaneous powers, but one that talks about rules. And the question was, that discussion in Section 6 of rulemaking, was it for housekeeping, procedural rules, or was it for legislative rules that have the force and effect of law? And what I decided and what I set forth in my dissent was no, that looking at the text and the context and the structure of the act, no, we did not have that authority. There was some litigation challenges, and the courts agreed with my reasoning, and that rule has now been vacated. But one important aspect that I made in my dissent was, that does not mean that I think all non-competes are good. We know that that non-competes can be bad for employees, it affects their mobility. We also know that non-competes have pro-competitive benefits. We know that businesses will invest in employees when there are non-competes, and that businesses have value and can be sold when they do have those non-competes available. So there is a cost-benefit analysis, and we need to really analyze the pro-competitive effects, the anti-competitive effects. And it's better to do that in individual enforcement actions rather than trying to do a lengthy rulemaking process that took up years and eventually went nowhere. So I have supported enforcement actions just recently, an enforcement action against a company. It was a pet crematory services company, and they had non-competes for virtually all of their employees. And we reached a settlement with them to get rid of that, to benefit about 1,800 employees. So those are the kinds of actions I would absolutely support, and because we need to be looking at these on a case-by-case basis to understand the pro-competitive, anti-competitive effects from these agreements.
Thank you. Do you expect to see additional things in this area?
Absolutely. In fact, we had a workshop that was scheduled, but got canceled because of the shutdown. And I anticipate we will reschedule that, and we will bring in experts and be able to talk about this and where we can find that balance and protecting both business interests and workers.
If folks in this room wanted to be involved in that workshop, is that something that would be an opportunity? I'm just hitting you with this question.
Yes,
here, so.
Reach out to our Office of Public Affairs and explain that you'd be interested. Yeah.
Okay, great.
We'd love to have stakeholders and inputs from various industries and backgrounds.
Great, thank you. Being this is the Life Sciences Summit, and their members include every part of the life science industry, including pharmaceutical companies. They're often blamed for the high price of pharmaceuticals, of drugs in the United States. We recognize the public doesn't always recognize everything happening behind the scenes, including the impact of PBMs, who can really impact that price beforehand, before things get to the market. The FTC recently issued a report that was very critical of PBMs. Can you tell us a little bit about that report, and then what the current thinking is in relation to PBMs?
Sure, yes. And just by way of background, this is not the first time that the FTC has looked at this industry. So back in 2005, we did a very thorough 6B study. 6B is our authority under the FTC Act to go issue orders to companies and get non-public information about different industries and markets. And we take that information and we typically produce a report, and that report can be very helpful to Congress, to lawmakers, to stakeholders to understand different industries and different practices. So this was done in 2005. As you can imagine, this is a very complicated and very complex area, and it was very thorough. So the commission, the previous administration, wanted to do that again and look and review this industry to see if there had been changes. And this was back in 2022. It was very politically fraught. You can imagine this is an area that is very politically heated. And in fact, they were not able to actually launch it at first, and economists actually quit over the initial launch, but eventually were able to get the orders issued, and the study has gone forth. This past year, the previous administration wanted to put out an interim report. And I dissented from that interim report for a couple of reasons. But mostly because the interim report had some structural observations, cherry-picked a couple of examples, but really lacked the objective, thorough, economic empirical analyses that the previous reports had done to really give us a good understanding of what's happening here. There are absolutely concerning reports over pricing practices by PBMs, including rebates and formularies and things. But to get a really good understanding, we have to do the work. And we can't just throw out structural observations with some cherry-picked examples. But most importantly, why I dissented was the report provided no insight into how consumers would actually be impacted by these practices. And I think that's what we really need to understand. So we are committed to finishing the study. And I believe that we will do this in a very thorough and objective and thorough way so that we'll provide the information that that Congress and others need to make any changes if necessary.
Thank you. Moving to a little bit different area of the things that you do. It's very broad. I want to talk a little bit about mergers and acquisitions. For life science companies, that is such a frequent occurrence. It's something that's happening all of the time. Some may narrow the market. Others might, make sure that they never see the light of day, some kinds of technology. You are charged with reviewing M&A activity to make sure that it's not leading to monopolies or that it's providing any kind of undue limits. So we have a series of questions for you here.
Sure.
We'll start at a high level. What would you say are the most notable differences between the Biden administration's approach to merger enforcement and those of the current Trump administration?
Yes, I think the most notable difference for our merger and acquisition enforcement is going to be in returning to procedural norms that were abandoned by the previous administration. And we've done this in a number of areas, but I'll talk about just three. First and foremost is our transparency and communication. We have, in the previous administration, they failed to articulate enforcement standards with the parties. They abandoned typical practice of communicating with parties, and we are committed to bringing that back. I think good government is when parties understand the expectations and compliance requirements, and so we want parties to understand that, and we're committed to providing good communication and having transparency about our enforcement actions. The second one is returning to what's called early termination. So when parties come to us, when there's a big merger, and they meet certain thresholds, typically $126 million, they have to provide what's known as notification form under the Hart-Scott-Rodino Act, and you might have heard this, HSR. And so they provide that notification to us. And as soon as they file that with that information, it starts a waiting period of 30 days. And during that time period, the parties cannot close their merger. It gives us an opportunity to review the matter, to review the information, to see if we want to pursue further investigation. If we do, then we would issue what's called a second request, and that begins a lengthier investigation. But during that 30 days, parties can also request that we terminate early. We terminate our review early and close that matter earlier than the 30 days. And this is, just to give you some perspective, 98% of the filings that we see never end up in a second request. So they are pro-competitive mergers that are going to go forward, going to benefit consumers. And so early termination can be a very good thing for the parties. They can get their deal done, but a good thing for consumers. Because if they can finish that earlier, then the benefits from those mergers can redound to consumers earlier. So this is a practice in the previous administration that they had stopped altogether. But we have reinstated it. And looking at the numbers as of the end of September 30th, if you look at it from a percentage, we are approving these 100 times more than the previous administration. We want deals that are pro-competitive to go forward, and we are going to get out of the way. And so I'm thrilled that this process is now back in place. There is a note, you have to ask for it. It's not something that we will do on our own. So parties have to come to us and request that early termination. But if they do, then we will look at it, and if there's not a problem, then we will make sure that a deal can get going forward. The third area in terms of procedural norms that we have reinstated, and it is very different from the previous administration, is remedies. A deal might come to us, a merger, And it might be very pro-competitive, except for like maybe a small portion. Maybe it's a product or two, or maybe it's a geographic location. And we work with the parties to come up with a solution. Maybe it's a divestiture of that product or of the product in that geographic location, so that the deal can move forward on a pro-competitive basis with removing that anti-competitive portion of the deal. And that's very important. It's important to parties. We want the deals to go forward that are pro-competitive. It's great for the agency. By taking that off the table, but the previous administration, we have removed all our ability to negotiate, all of our leveraging ability to work with the parties. So that is returned, and we have done it. We have worked with parties and come up with solutions in various areas where we're able to work out a divestiture so a deal can move forward. And so that's an important part of a change in this administration.
I didn't want to cut you off while you were answering, but you mentioned the request for early termination.
Yes.
How frequently do you see those? How many companies take advantage of that opportunity to make that request?
That's a good question. I have not looked at the numbers yet, but I think it's not up to where it was before, even in the previous Trump administration. So I think the numbers have dropped, and I'm hoping that parties understand we are open for business and looking at those.
Okay, thank you. Keeping on this topic of mergers and acquisition, under the Biden administration, their approach seemed to be that startups should maybe expand organically via IPOs. What is the current approach or perspective on how acquisitions of startups should be handled, and how do you expect that to be handled under the current administration?
And that's a great question. The previous administration did state that they believed that that the laws favored IPO or organic growth versus acquisition, and that's just not true. That the antitrust laws, they do not favor either. And I think it also, there was a general hostility in the previous administration to mergers and deals and trying to kill them in the boardroom, really. And I think that is such a disservice to our economy, because mergers and acquisitions are a critical component of our economy and economic growth. We know this. We know that M&A is so important for innovation. So if you have someone who has an idea, an entrepreneur, an innovator, they need capital. They need capital to get that idea off the ground. But investors are not going to go to an idea and bring money to it unless they have an exit path. And so if you take that away from them, that exit path, you're really taking away the entrance of that capital to those ideas, and it can really harm innovation. So I think it's important to understand how M&A is so important to growth and to innovation. I mean, just to give you kind of a perspective, in the last 3 years, there were only 55 IPOs. So obviously, it's not going to be a solution for everyone. And particularly in the life science industry, M&A is so critical, as we've seen, and we understand that not every company, not every scientist who creates a new drug, a new device, is going to have the ability to scale up, is going to have that ability to bring something to market or commercialize it. And so having the access to that is very important. And we understand that, and I think we go into it with that perspective. That said, not every deal is good, and we will be scrutinize these deals. I did support an action recently against Edwards, which I'm sure many of you have heard of. But this was a very unique case. This was back in the summer. Edwards, over the space of 2 days, bought 2 companies, JC Medical and JenaValve, and both of these companies were in clinical trials to create a device to treat aortic regurgitation. And so we looked at that, and we were very concerned that this deal would eliminate that head-to-head competition, so I supported that. That is going to court in the next week, so I won't speak anymore to the questions, but I will say it was a very unique situation, and I think it presents some unique questions for the court.
That's great. Thank you for addressing that. There's also been a lot of reporting a lot of acquisitions have been in the news, but particularly there's been a lot of reporting regarding the Pfizer and Medicera merger, including the involvement of the FTC. So can you maybe tell us a little bit more about that involvement, that case, what's going on there?
Yes, and this is an interesting case. And for those who maybe have not seen some of the coverage, so Novo Nordisk and Pfizer were in a bidding war for a company called Medicera. There are the two leading companies right now for GLP-1 drugs are Novo Nordisk and Eli Lilly. Metsera is providing a new technology in this area. So Novo Nordisk and Pfizer got into a bidding war for this company. The FTC did get involved. And to give you a little bit of background on HSR for a minute, we talked about HSR, the forms that come in, and we're looking at a deal for the substance, right? Looking at whether there's going to be anti-competitive effects from this. But we also look at procedural violations. And one of those violations is called HSR avoidance. So HSR avoidance is when parties structure a transaction to avoid having to file HSR forms and deal with the FTC. And this came up a couple of years ago in a case with Toshiba and Canon. Toshiba was experiencing some financial irregularities, and so they wanted to get rid of one of their subsidiaries, and they needed to do it quickly. They needed to do it before the end of their fiscal year. So they structured this so that Canon could purchase one non-voting security for $6 billion. And then later down the road, Canon exercised their option to create that into voting securities so that they had all of the voting securities of that subsidiary. So when we got involved in this most recent case, you may have seen reporting of a letter that went from our Bureau of Competition director to the parties regarding Novo Nordisk's bidding in the bidding war with Metsera. And what the letter said, contrary to some reporting from some various media outlets, the letter made very clear that we have no opinion on the merits of any of this merger, on whether it would be anti-competitive, a merger between Novo and Metsera. We also have no opinion as to the merits of any procedural violation. But this deal between Novo, this bid between Novo and Metsera, Novo's bid looks a lot like Toshiba in that it was an offer for $6 billion for a non-voting securities with no options for other consideration in order to gather those voting securities. And so what we said to the parties was, we would like your cooperation in reviewing this. This is part of our job. We review procedural violations. We investigate those. And we'd like you to cooperate with us to look at this. Again, making very clear, we have not made zero determination as to the competitive effects, as to whether there would be procedural violations. But please work with us, as you normally would, to review this and understand what is happening in this area. And so it looks like Pfizer won the day. They won the bid, and this will be happening this week. But I think as far as how the media has portrayed it as us trying to get involved in this bidding war, that is not at all what we were doing. What we were doing is what we always do, which is working with parties through this process, communicating, just as I had talked about in terms of transparency and communication, telling the parties, this is how we view the law, this is how we are going to approach enforcement, and please cooperate with us as we review these things. And I think we will remain committed to providing transparency and communication with the parties as we continue to review both procedural and substantive violations of the HSR Act.
Can I ask you a little bit of a follow-up question there? So if you were to give advice to companies about how to work with the FTC or how to approach these kinds of things, any advice?
Yeah, and I will add one extra additional point to that case. What is also very interesting about that, Novo had an original bid earlier this year for Metsera, and the Metsera board had rejected it, not just because it was low, but also because of the regulatory risk. So they understood what was happening there and decided not to proceed with that. So, of course, when a transaction comes up and all of a sudden there is no regulatory risk involved, that raises some alarm bells for us on what is happening here. Making no determination but understanding, oh, we're going to look at this. And I think that is something that companies can think about, is if you are aware, and if your lawyers are telling you, you know what, you likely will be involved in some regulatory review, but then some very clever transaction comes up, maybe it's okay, maybe it doesn't violate the HSR, but it might also likely require some review for us to understand if there is some potential violations there in avoiding the transaction. I think the second point that I would make about that, and which the letter talks about too, is also called a gun jumping violation. So as I mentioned, when you file an HSR form, that starts the 30-day clock. And during that time period, you cannot close, but you also cannot start to do things that look like you are closing or integrating, including sharing confidential information, requiring certain acts that you could not do if you were had not merged. And so we look at those very carefully too, and that it could be a separate violation if you're requiring certain things, if you're sharing confidential information that you could not share as non-merged parties. That is another thing that we are going to be looking at, and something that for folks to consider as they're proceeding through mergers.
Thank you.
But I should end with, I believe that mergers are pro-competitive, and I think the vast majority are going to go through. I think they're great for the economy. I want them to happen. Of course, we'll be looking at anti-competitive effects, but if there is not a problem, we will get out of the way. I think it's really incumbent on good government we of course want to do our job. We want to be collecting the information we need to do it effectively and efficiently, but we want to do it with the least burdensome process as possible.
Thank you for that clarification there. There's currently the Uniform Law Commission, and I don't know if folks are familiar with the Uniform Law Commission, but it's a group made up of lawyers really from every state that comes up with laws that they propose in every state that they think should be the same for all sorts of reasons, right? Whether it's competitive reasons, trade reasons, in between states for industry continuity, they propose these laws. Every state has the option to adopt them. The Uniform Law Commission is currently proposing a law that would require companies to file their merger documents not just with the FTC, but with all 50 states. This has been rather controversial. There was a conversation about this here in Utah during the last session. What is your approach to this particular law? I know there are those who think that this would be a significant burden. There are others who think that this would really help companies have a better ease maybe as they move into other states. What is the FTC's current approach on this?
Well, again, I'm speaking for me, not for the commission, but I personally think this is very concerning to me. I would be very cautious about something like this. Deals move forward. There is a margin for not moving forward on a deal, right? If they understand as you're putting a deal together, that the costs that come with that, the costs of the regulatory compliance costs and all of that, and if it seems like it's going to be too costly, the deal will not go forward. That is not good if we are just adding process on top of process. If we are just adding burdens that are going to stop these deals from going forward, that is not good. That is not good for the economy. That is not good for the parties. That's not good for innovation industry at all. And so I think we need to look at this, like, what would this be accomplishing? I think it would be just process on top of process for a number of reasons. I know folks have argued, well, we don't really have great coordination with the FTC in the states, and that I would push back on. And as I had talked about, when I was in the state, I worked with the FTC. And as I'm in the FTC, I'm working with the states. And there is coordination. Could it be better? Sure. And I think that's where we should focus our efforts rather than piling on burdens to the parties. That could prevent deals. We should not be doing anything that could unnecessarily prevent deals from going forward. So I would be very cautious in trying to proceed with this.
Yeah, I haven't paid attention to how this is going amongst the different states.
Yeah.
Has it gotten much traction?
Not that I have heard of, but I think a couple of states they're seriously considering it. I think that's the other pushback that I would give to folks when they're saying, well, it'd be the same everywhere, so it wouldn't be that much more process. And I would push back against that. And as folks who have worked with the state legislature understand, there might be a proposed uniform bill that comes to a state, but it's going to make some changes. And so I would suspect that every jurisdiction might have some variation. And the ability for companies to have to deal with the variation in those 50 jurisdictions would be very difficult. But not only that, once let's say that burden is imposed, you are now beginning a communication with a different jurisdiction. There is going to be likely an attorney general in every state who would receive those forms. And they might want different information about that form, not because there's any particular concern. Maybe they want to be relieved of some issues or whatnot. And it might be a completely benign merger, which doesn't even impact their state. But you risk having those communications and that additional burden to have those with every state. Would absolutely increase the burden. It would be really an additional merger tax. And if you want less of something, what do? You tax it. So if we want less mergers, then yes, we should proceed with a 50-state burdensome requirement for additional HSR forms.
Thank you. One final question. Your website talks about how the FTC is constantly reviewing its rules and its regulations to make sure that they're still up to date, that they're still the most effective, that they're still the most appropriate rules there. What does that change look like, or what does that review look like from a transition from an administration to administration? Many of the commissioners stay the same. Sometimes they don't, right? But what does that rule review look like? What should people expect to see as you kind of review those rules? Does it ramp up, or does it stay about the same?
No, I think that's a great question. And I think some of it also is there is a triage process to this as well. Some of the most difficult things as an agency is presented with is where to put resources to what. And to understanding what do we want to spend our time on? Do we want to spend it on this particular enforcement action, this regulatory action? So that becomes very difficult as a new administration comes in and we're basically doing the inventory. What rules do we have, and where can we put our efforts? Is one of the most difficult questions you have. And where would you rather focus on an enforcement action? This is similar to what I was talking about with the non-compete rule. Would we rather spend a significant amount of resources developing some certain rule? Would we rather put those resources to a few enforcement actions, which can also be very beneficial in terms of signaling to the market, hey, this is how we viewed certain practices. We think these practices are unlawful, and we think you should act accordingly.
That's very helpful, so thank you. And again, we just want to thank Commissioner Holyoak for being here with us today. Really amazing that you are here in the state with us. Particularly special that you would take the time during the shutdown. I know your resources are limited, so thank you so much for taking the time to be here with us today. We really appreciate it.